Understand some of yours are still valid. Mine are mostly expired.
Well, some of yours were never valid, but we'll leave it at that.
You know, Tom, I pointed that out earlier.
Let me just say I have a great appreciation for what you do, Commissioner Focarino and Mr. Budens, what the folks that you represent do. It's a constitutional duty, and it was prescribed in our Constitution to grant, for limited periods of time, exclusive rights to the inventions to the inventors. And I take it very seriously. I want to back up before I get to my specific questions about the subject matter at hand and just say, here in Congress, I think it's our obligation first to do no harm to the patent system. The big picture here is to encourage and protect innovation in this country. Some would consider this off topic, but I don't think it is. Mr. Budens, you represent how many patent professionals, examiners, and professionals at the patent office?
Approximately 8,500.
So
most of which are examiners.
So over 8,000. Were you ever called to testify on the Innovation Act?
Not that I recall specifically for AIA. I've been up here. This is my third trip up here.
But you wrote a letter last year about the Innovation Act, right?
Yes.
Okay. It was actually a year ago today, and you had some concerns with the Innovation Act. Can you tell us what those were?
I haven't got it fresh on my memory.
I'll just ask you if this is what you said. A broader concern for POPA is that the Innovation Act appears skewed against small inventors, and that you encouraged us to make sure that anything we passed wasn't skewed against small inventors.
That would be accurate. I'm sure. I can't say word for word, but I would assume that's the position. That has been the position, both my own personal position, but also the official position of POPA, you know, for as long as I've been involved in it, that we support a strong patent system, and we want to make sure that the small inventor never gets squeezed out of this.
But that was your concern with the Innovation Act. That was my concern, too. That's why I voted against it. And hopefully we won't bring that up again, and hopefully it won't pass the Senate. But that's because we're trying to fulfill our constitutional duty to protect innovation. Now let me get directly to the matter at hand. First of all, Commissioner Focarino, I realize this is not such a high bar, but I will tell you that my friends who are innovators in the medical device field asked me, why can't the FDA be more like the patent office? So that's sort of a backhanded compliment for what you do there, and we appreciate that. Also, it seems like today we're talking about activity, tracking activity, and not so much progress. And a wise person once admonished me, never confuse activity with progress. But activity is a precursor to progress. You do have to have some activity. So, and what's apparent to me here is that telework is not necessarily as much a productivity enhancer as it is a recruitment tool. And this was true at my company when we allowed telework. And I can tell you there are some people who are not cut out for telework. They just don't do well independently in their house with kids, you know, running around and whatnot. And so I think it works to your advantage with some employees and to your disadvantage with others. And I think you have to acknowledge that if you're going to manage people in a telework environment, that not everybody's cut out for it. Let me ask Mr. Budens. Mr. Smith had some what seemed like good advice, a couple things he mentioned, and get your feedback on those. He said maybe we should break down the hours by patent examining activities and track it that way instead of just activity. Do you think that would be helpful?
I think it would be very difficult to do because it would be so varied across technologies. For example, and when I examined
are there some technologies where it might be appropriate? Surely the manager could adjust.
It might be, but I think that it's already relatively built into the system in the goals that we have as examiners. of looking at, you know, how much time do we have to spend searching in this particular
Right.
technology or that?
So some of it's done already. Let me ask you about another one of his suggestions.
Okay.
And correct me if I'm wrong, Mr. Smith. You recommended that perhaps new examiners should be within commuting distance of the office
New examiners who are newly approved for the teleworking program?
for the teleworking program. What about that idea?
It's certainly one to think about. I think that one of the biggest problems we would have initially is that a lot of the people who want to telework and a lot of the advantages that we've gotten out of telework, we're being able to hire people from pools that were away from the agency. In other words, we've now been able to hire people who work in Silicon Valley much better
There are
than
4
we can.
branch agent areas, right? Is there one on the West Coast?
Right. Now that we have 4 regional offices, I think, in my view, a prospective patent examiner would have a choice of 5 very nice, diverse areas that they could relocate to if that was what was needed.
Commissioner Focarino, do you support mandatory online presence indicators for patent examiners working at home?
I'm in favor of any tool that improves collaboration and communication with our examiners, and no tool is going to be a time and attendance tool, so I want to make that clear, but these tools are meant to make communication efficient and very collaborative, and we have some really great tools, particularly for the interviews that you just mentioned.
And just a quick yes or no, Mr. Budens, do you support or oppose mandatory online presence indicators?
It
Just a
depends
quick
on,
yes or no, my
it
time.
depends on how they're used.
I'd
Again,
give you more
for
time if I had it.
collaboration, we already do that. Everybody already uses
Would you
them.
support mandatory? Yes or no?
I can live with mandatory as long as they're not being used as to verify work, attendance.
It's activity, not progress.
Collaboration-
I understand that.
For
Thank you very much.
collaboration, they're wonderful tools.
Thank you, Mr. Chairman. Thank you, witnesses.
I thank you. I wonder if the fellow that had the automatic mouse mover as part of his workstation, whether or not he would agree that it should only be for collaborative oversight.
Well, there's a program you can get to defeat the automatic mouse mover tracker, of course.
Well, by now I'm hoping they have it after that report. The gentlelady from the high-tech capital north of California, Ms.
And home of the future patent office.
Well, yes, I'm
San
well
Jose.
aware of your winning out over San Diego due to some unfair competition at the time.
Thank you, Mr. Chairman. I just want to make a quick correction. Mr. Marino mentioned that there was, money from the taxpayers, and in fact, there's no taxpayer money here. It's all fees. It doesn't mean that if there's a problem, it's okay. It isn't okay. But if there was a loss, it was the patent applicants who lost. It was their money, and they're not happy. And I hear from a lot of patent applicants in Silicon Valley want to make sure the system is working well and are not happy about the built-up delay time, and this news was frustrating. So I just wanted to pass that on to you, Commissioner. Mr. Zinsser, I wanted to address some issues of concern to you. Now, inspector generals and their offices are normally just beacons for whistleblowers, and the IG system, I think, has a problem when whistleblowers don't trust them or even feel threatened by them. And I think you've had a very troubled relationship with whistleblowers that I think is of concern. In 1996, when you were the Deputy Assistant IG for Investigations in the Department of Transportation, the Office of Special Counsel found that you personally retaliated against a whistleblower in your office named John Deans. They determined that you retaliated against Mr. Deans because, and this is a quote, he discovered violations and politically embarrassing information about high-level government officials and community leaders, unquote, related to the potential diversion of federal funds. And the OSC described your behavior as draconian in nature and motivated by animus. OSC also determined that every allegation you made against Mr. Deans when you proposed that he be fired was unsupportable. And in fact, a settlement was reached that reinstated Mr. Deans, paid him 11 months of back pay and benefits, paid his attorney's fees, allowed him to move back to his Denver office and away from you until retirement, and removed any allegations about him from his personnel file because they were completely false. Now, as disturbing as that was, I don't think it's an isolated case. Last year, 2 of your closest and most senior members in the Commerce Office of Inspector General were found by the OSC to have retaliated against whistleblowers in your office, although they found no, and I quote, documentary evidence that you were directly involved. This year, however, the Committee on Science, Space, and Technology has been engaged in a bipartisan investigation of your office involving allegations that you personally and your newly appointed Deputy IG have been attempting to identify and retaliate against employees in your office that you believe have been cooperating with the congressional investigators and OSC. Now, I want to raise this relative to the PTO office because your office conducted an audit in February of 2012 on the PTO's telework program, and your audit found, quote, USPTO's policies for managing PHP comply with applicable telework laws and provide reasonable controls and assurances that the program operates effectively and efficiently. And it concluded that, quote, USPTO has adequate controls over patent holding programs in key areas. Now, the report found that telework examiners were actually more productive than other examiners at headquarters, and that the PTO had saved millions of dollars and unavoided costs as part of this program. Now, it's my understanding that at the same time your office was issuing this report, you were receiving complaints from whistleblowers that the program was rife with abuse and potential fraud, and that rather than investigating those issues raised to you by whistleblowers, that you actually sent those allegations that could in fact be even criminal conduct back to the agency itself to investigate. And so I have a concern. I wonder how the audit staff, number one, could have been so far off the mark when they issued their February 2012 report, and how far from the ordinary practice is it for whistleblower allegations that might even constitute crimes to be sent back to the agency itself to investigate rather than the IG's office? Also, how can you and your office continue to function effectively when you have such a blemished history in your treatment of whistleblowers? And how can we trust that you will stop what appears to be a 20-year pattern of retaliation against whistleblowers? And finally, I am concerned and would like to know why you did not disclose the John Dean's case of retaliation to the Senate during your confirmation hearing to become Commerce Inspector General.
Well, there's a lot there, Ms. Lofgren, so let me just take your last...
Take your time and go through them. We'll be patient.
Okay. With respect to my confirmation hearing, the John Dean's matter occurred many years earlier, and that matter did not come to my mind when I was going through my process. It never came up in the FBI investigation. I did not consider myself, at the time anyway, a subject of an OSC investigation. And Mr. Dean's matter, very complex situation where Mr. Dean's himself had allegations against him made by the United States Attorney in Colorado that had come under investigation. And yes, we did settle that matter. And both sides of the story have not come out on that case. With respect to whistleblowers, I think our office has no problem receiving and investigating whistleblower complaints. In fact, I think one of the problems that exist at the Department of Commerce is that the management at the Department of Commerce has not taken ownership of the problems that are reported over our hotline. And we have been working with the management for several years now, since I've been the Inspector General, for the management to take ownership of their problems. The specific whistleblower allegations that came in about the telework program were not exclusive to the telework program. It was about how the management treated allegations of time and attendance abuse. And none of those allegations made specific allegations against specific individuals that would warrant us opening up a criminal investigation. They were basically rants against the management, and in our view, the management needed to hear them and needed to address them promptly, and that's why we sent them to the management. Now, we are doing additional follow-up investigation, and if the investigations lead us to where we need to refer things for prosecution, we will do that.
Mr. Chairman, I realize my time has expired, and I did have a long set of questions.
No, if there's any that were unanswered, you can do a quick follow-up.
I will, but actually what I might do, since there are other members waiting, is to take the opportunity to follow up after this hearing to actually inspect the allegations and whistleblower complaints that Mr. Zinsser has referenced and pursue the other allegations.
And I'd look forward to doing that with you.
That would be wonderful. Thank you, and I yield back.
We now go to the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. This is, again, very frustrating, you know, coming out and coming back to this oversight, not only with both committees, which I serve on, Oversight and Judiciary, and also as one who is a very strong advocate of creators and patents and this whole issue. Commissioner, one of the issues that I have is I've been a strong advocate of ending the PTO fee diversion, and co-sponsored legislation with my colleagues on the Judiciary to end this, and I've defended the integrity and efficiency in the management of PTO. To say that I'm disappointed at this point is beyond the pale. It's hard enough when you prioritize and try and help others understand the prioritization from what I feel like are valuable protections, constitutional protections and statutory protections that are found, and then when we're trying to actually get more help to do that, to find that these are going wrong is not something that I personally can tolerate. If you can't act really as a good steward of your resources the agency has given you, why should I as a member of Congress consider giving additional funds or trying to end something that is wrong if at this point you can't better utilize what you've got? Commissioner, Ms. Pecorino?
Thank you for the question, Congressman. I want to reiterate, we take these allegations very seriously. We acted immediately as soon as we got the first whistleblower complaint. We do take our management responsibilities seriously. It's a large and complex agency that we're managing and growing, and it's challenging, but we are very serious about addressing these allegations and the isolated cases of abuse.
Okay, and again, I think the biggest disconnect, and I've been up here really 2 years now, the biggest disconnect I have found is in many times outside the Beltway, there's a difference in correcting a problem than inside the Beltway. And the inside the Beltway is, well, let's study it, work at it, look at it, think about it. Maybe there'll be some members of Congress who'll forget about it. Maybe we'll have another hearing and then get to it. Out in other parts of the world, that's not the way it's done. Because this is not, to me, it's been sort of a longer-term problem. Commissioner or the Inspector General, either one, you're familiar with the term inloading, correct?
Yes, sir.
Okay. You are, Commissioner?
Yes,
okay.
I am.
Go ahead and put the slide up here, because this is a concern that I have in the report that was issued, 30-page report, basically talked about that directors and supervisors believe that inloading would compromise quality of work. What you're seeing here is analysis of data showing inloading by patent examiners suspected of cheating on time and attendance. And as you can see at the end of each quarter, going back to the first quarter of 12, that there is a direct pattern of inloading here. So I have a question, and we talk about finding out stuff. This has been going on for several years. What is the process for inload monitoring? What was being done to look at this, and why would this not have at least cast a red flag? Either one of you.
I'll be happy to start answering the question, Congressman. End-loading in and of itself is not necessarily a problem. It's
but
not.
Yet, well, hold on a second. But in your 32-page report found 71% of supervisors interviewed and 90% of the 25 directors interviewed believe that end-loading could compromise the quality of an examiner's work.
And we are concerned that supervisors believe that, and we have mechanisms in place for when that type of output occurs, that the supervisor is compelled to do an enhanced quality review on the work product. But as I said before, end loading in and of itself is not necessarily a problem. Some examiners do their work in parallel. They do searches together for similar applications, and they're in process, and then they submit them for credit in one bulk
Well, look, I think everybody in this room has ever had a college class or even a high school class or even just an online class. Yeah, you'll wait till the end, but that's not the best way to do work, and especially when you're dealing with something. And let's take it out of here for just a second. We get into our patent court, we get into the court cases, we get into defending these patents, and we got a lot of other patent, troll legislation and everything else. If we can't depend on the right work getting done in the patent office to start with, and it not being monitored for 2 years on end loading, which is, okay, some is okay, but this is a pattern here. And if you look at this, it is a direct pattern at the end of every quarter. It's not a once-off thing. I think this is the concern that I'm having. So in my little bit of time left here, because if you cannot understand the frustration of my voice, I am very frustrated at this, because as someone who defends creators and wants this to be taken care of and our business to be modeled, to not be able to look at this is a problem. So I'm going to flip it. I don't want to hear what the PTO you think you should do. I want you to hear what do you think we should do? What should Congress do when we see this kind of abuse happen? Especially for those of us who have defended the office and also defended the patent ending, the fee ending diversion. What do you tell us? What should I do now?
Well, I want to say that I would like to tell you what we are doing to address the problem. And I would like to preface this by saying when I was an examiner in 1977, end loading existed.
Nobody has denied end loading, ma'am. Nobody
Yeah.
has denied end loading existed. What we're having a problem with is supervision here. There's
Right.
just a pattern of letting it go without seemingly anyone taking
We have
time
a
to say,
quality
maybe there's a
check.
problem.
Yes, sir. We have a quality check in place, and we've recently, we piloted a program in a technology center with 1,000 patent examiners to specifically address this issue. It began in December of 2013. It was very successful. It reduced this type of behavior significantly, and now we've implemented that program across the entire core of 8,500 patent examiners, and we hope to see significant improvements. So we are very concerned about it. We're focused on it, and my point was that in and of itself is not necessarily a problem, but it can be, and when it is, we address it.
Well, I think telework can be a good thing. I've worked on it at the state level, worked on it here. However, what does disturb me is basically what you said. When the actual report of your supervisor and your director said it could be a problem, you just said it's not necessarily a problem, and that basically you were upset with your supervisors for saying this. That is that right there to me is saying there's a disconnect maybe from the top level to the supervisor and director level, saying maybe we're not sure what we should be looking for. I'm going to be following up with follow-up questions for the record in writing on this, but please understand this end loading issue and other issues here for those of us who want to defend this office is not acceptable, and frankly, your answers left me lacking a great deal. Mr. Chairman, I yield back.
Thank you. Just for the record, since you're answering, as I understand it, the supervisors, if you dump or end load, you dump 16 patents, they only have a matter of hours to respond because they have a timetable. So spiking also denies proper supervision, doesn't it?
It certainly makes it challenging to review large volumes of work in a short period of time. So what we typically do is add additional resources. We have quality assurance specialists that look at the work to assist our supervisors when these situations occur.
Mr. Chairman, could you
yes.
yield to that? I mean,
I'd ask unanimous consent the gentleman have one more minute.
Just for a quick. So basically what we've done to save money and to save process, because end loading was not properly supervised, we've had to expend extra resources to deal with the end load dumping that occurs to make sure that these were done right. Is that what I just heard you say?
I didn't say that, no. I said we have
Okay,
quality.
exactly what did you say, ma'am?
I said we have quality assurance specialists that when this situation exists, they can assist our supervisors in the review process should they not have enough time to review a large volume of work.
But if they were done at a proper time, then they would not have to be as involved with such many at the end. This is absolutely, it's going in a circle. Mr. Chairman, I appreciate the indulgence. Thank you.
I thank you. And Mr. Smith and Ms. Koplinger, you look at the effects of that kind of a spike and not enough time for the supervisors to look at it, don't you? You want to weigh in on what that might do to the patent quality from your experience?
I do have some views here, and I think that's one of the basic problems as a patent practitioner that we run into. I think it's part of this count culture that I think is the biggest cultural change that we need to make in the system, where patent examiners are not of the mindset that they're being paid to do piecework, that there's a continuous consideration of the case until it's ultimately determined to be patentable or not. The phenomenon known as Count Monday, I think, is a recipe for disaster. One quick anecdote, a few years ago, there was a patent that issued, element array. One of the elements specifically said in the patent claim that operated at a speed bigger than the speed of light, which would certainly raise the eyebrows of most physicists. And when I asked the manager in charge of that unit, how could that possibly have been passed through, and he just shrugged his shoulders and said it came in on Count Monday, and the SPE had 50 cases to review. So I think, again, the take-home lesson is not so much about telework as it is that the underlying management systems need to be reformed.
Thank you. If you have any other comments.
Yes. As I indicated, if an examiner does a very large proportion of the work at the end, it does, in my mind, raise quality issues. What you have to consider is how much is being done and what the circumstances are, because sometimes it does not equate to a quality issue. One thing I would observe about the spikes, it's true that you see those spikes which represent to some extent some undesirable end loading. Some of it actually also is a portion of the work that's sent in by us, the practitioners, which also reflect a cyclic pattern, which we had uncovered when I was at the patent office, that during a week, the work comes in to peak on Fridays. So the examiners are tasked with doing the work based on those time frames too. So it's sort of like to some extent, a vicious cycle.
Mr. Smith.
Yes, I think that with the end loading problem, if my suggestion about changing the time accounting system, these are systems that law firms use all the time. When I'm doing a prosecution matter, I put down our internal client matter, and then how many hours I worked on it that day, and then for those, a slight narrative as to what exactly I did for the client. On a litigation matter, when you enter the matter number, there's another menu that pops up with 20 activities, appeal work, client counseling, depositions, all of these discrete tasks. And there's also software that law firms use. At the end of the day, it's called time management software, where you get a report based upon your computer usage, your telephone usage, as to what activities you actually use. And I think that if that software was in place, it would be interesting to see if a patent examiner did 80 or 90% of their productivity at the end of the quarter, how was their time spent in the first month of the quarter? And that can only be tracked by application and task.
Thank you. The gentlelady from Texas, Ms. Sheila Jackson-Lee.